When you see inventions coming out of the universities or intellectual property coming out of different university settings, what are some of the most common pitfalls you see? I guess to you two, in your practices or whatever that you've observed, and Todd, what are some of the biggest ones you've fallen into? Do you have any thoughts or anything come to mind?
Well, I've screwed up about everything you can possibly screw up. So, when I did Vital Source, I was very emotional about it. It was like a child. You create this idea, you're going to create a company, you go through all the issues. The thing I've learned over 25 years is don't get emotional about it, be pragmatic and be logical. You were talking about being problem solving. You're always dealing with, should I protect it and pay the money for the patents, or is it worth it? And deal with that with tech transfer all the time. The other thing is, don't get romantic about what a company is. The theory is that you're doing this patent, you protect the intellectual property, you do the tech transfer. Whatever the resultant company is created, whether you're just creating it to license the technology or you're expecting to run it, don't be emotional about it. Do it, understand that a patent, a copyright, they're just tools. They're business tools that you need in order to commercialize. And the structure of the actual company is just an instrument as well. And it will change depending on what it needs to be. And I was an academic and thought that I could figure it all out, that I was smart enough to be able to sit down with a piece of paper and go, I'm going to do this, and then I'm going to do this, and I'm going to make this company, and this is how much stock, and then I'm going to hire this. Don't do that. Think of it very much as, what's the next process along with it? What do I need to protect? You're always dealing with intellectual property changes, but you're also trying to figure out the best path to commercialization. And I found that the more things that I felt in stone I figured out, sometimes it hurt me to actually implement what I needed to do business-wise. So even though you come up with this great idea and you say, I'm going to create this company, I'm going to run it for 50 years and it's going to be great, just realize that things change, markets change, and that don't get emotional about it, be pragmatic. And I made both mistakes, I'll be honest with you. I got emotional about Vital Source, and it hurt me for about 3 years making business structure changes that if I look back on now, I would have made different decisions.
For me, in determining inventorship, so in some instances, some contributors to the science have difficulty assessing who's an inventor. So first of all, who is an inventor? An inventor is someone who's contributed to the conception of the invention as claimed in the patent. So let's break that down a little bit. So we're looking at the patent, and if you see a patent, you see that there are these numbered claims at the back of the patent. Those define the metes and bounds of the invention, the limitations of your invention. An inventor is someone who's contributed the idea and the complete thoughts and operative invention as recited in that patent, in those claims. It's not just someone who's worked on the invention, or someone you really like, or someone who's nice, or someone who's, I don't want to get in trouble here, but the department chair, so we want to just make sure that person's named. They must have made a contribution. And that's very important because several reasons. It can invalidate your patent. It can render your patent unenforceable. And as Todd's mentioning, if you're trying to sell the technology or license the technology, when you undergo due diligence, that acquirer wants to know, okay, do you have assignments? Who are the inventors? Because at the end of the day, this is a business interest of theirs, and they don't want someone coming out of the blue saying that they have rights to this, because that puts everything in jeopardy. So it's very important to determine inventorship and understand who an inventor is and make that determination correctly.
I think resisting the urge to talk about it is one that I see a lot. And do you represent the undercover colors guys from NC State?
I do not.
We do not either. All right, Hutchinson does. So there are these guys at NC State who
just make sure.
Yeah, just to make sure. They came up with an idea for a fingernail polish that girls can wear out to bars, and if their drink has a date rape drug in it and they drop their fingernail polish into it, it'll turn bright red. And that's a great idea, right? I mean, that's an idea that really has a nationwide, worldwide market. But they're on TV 10 minutes after having the idea at WRAL, News and Observer, they're Triangle Business Journal. Those guys are everywhere. They didn't go through the Office of Tech Transfer. They hired attorneys privately, and they've raised $1 million, right? So maybe I'm wrong about this, but I have concerns about whether they actually have anything beyond the trademark undercover colors, whether they actually have patented technology. And if you're a fingernail company, Revlon is one. I mean, you just see that idea and you say, I'm taking that. That's in the public domain. So just having some discretion about, you might have a great idea, but you don't have to market yourself immediately.
And getting non-disclosures. I mean, that was another thing that I screwed up. So guys, making sure that you get a good non-disclosure structure written. You can't always just use a boilerplate. I mean, there's this theory of, well, get me a non-disclosure and I'll just sign your mutual. A lot of times the technologies that you have need to be more specifically defined than in a boilerplate. And boy, I wish I'd done that differently. So when you go out and you're actually disclosing, make sure it can't be just, okay, we're going to meet with you, we trust you to sign the non-disclosure and send it to us. You don't have the meeting if you don't get the mutual non-disclosure. And guys, I'm just telling you, don't screw that up.
And taking that a further step, if you transfer any material, do that under agreement
email
as well.
Watch your emails. Just make sure, just putting it's confidential at the bottom, nah. If you're disclosing it, you're disclosing it. So,
and an example of Todd's point, yesterday I looked at a contract that one of the big electronics companies in the U.S. was asking our client to provide their technology for them to take a look at. And they said, look, here's our mutual non-disclosure agreement, sign it, we'll take a look at it where everything's above board. But the term of the confidentiality duration was 1 year. And so 1 year and 1 day later, this enormous company no longer has any obligation to keep it confidential. They just sit and play four corners, and then a year later, they've got your technology. So I think that's a great point, that the boilerplate NDAs are worth reading.
Also where it's enforceable. I mean, if you sign a mutual with another company and they're where they can litigate it is in, I don't know, Utah and, whatever, you got to be careful that they're playing on your ball court because you can get in trouble really fast signing mutual non-disclosures just because you're really excited about a big company being interested in your cool idea. Those NDAs are unbelievably important.
That's an article that I should write, so I'm going to take your intellectual property having announced that. That's on my to-do list now. That's good.
So Todd, in your comments Will, in your comments a minute ago, I was looking at Todd, you mentioned something that kind of caught my interest. You talked about people for undercover colors using outside counsel.
Yeah.
I mean, do we have any legal ownership issues we have to deal with as a faculty member and being an employee of the university?
That's a great question. These were students, and that's the big difference, is that it wasn't faculty members where there's a claim that it belongs to the university. They were students that participated in NC State's incubator program, but ultimately weren't university residents, employees.
But yes, you do.
But yeah, I mean, that's a huge issue. Todd probably can speak better to it than I can.
Well, I mean, the reason why I had theories of what became XComp a while ago, but I wanted it in a university. And it's really odd. You would think, oh, well, he's created companies before, so why wouldn't he just hire an attorney and do it? The technology I was creating needed to be in an academic institution. I think I talked to you about that, Will. And so I knew on purpose that when we did the tech transfer, we would be going through the Office of Tech Transfer with the legal issues and sharing. But I felt like that's what I wanted to do with that technology. When we did Vital Source in '94, I actually had the attorneys from University of Texas in Austin come knock on my door and said, your research looks more like product development, we would feel a lot more comfortable if you would take it out. I think it depends on the technology and it depends on the intellectual property. I felt like what I wanted to do with XComp was to actually have it be in an academic institution, but you have to make that decision. If you decide to go outside, you still have the responsibility of working through the university in order to get it free and clear, and those are other issues. Those are pretty easy to do, and University of Texas was great when I did the vital source transfer. Let me be clear with that. They were great. But at the same time, it depends on the technology and it depends on what you're going to do with the company. So there's no real answer, but yes, if it is within the university, there's a report of invention that goes to the university, and then there's a decision the university makes relative to how they want to protect it. And Marty in Tech Transfer is very, very good at that. So, like I said, I've helped with 6 tech transfers and 9 companies. Our university is very good at handling this, and I'm more than happy if anybody has any questions about that, to be a resource.
So in other words, the ownership part of it can be a little complicated, and we should work with folks at the university to make sure that we take the right path there.